Yuma, hello everyone. Delighted to be with you. I too would like to pay my respects to the traditional owners of this land, the Ngunnawal and Ngambri peoples. I acknowledge their continuing contribution to this region, and I'd like to acknowledge all Indigenous people in the room with us today as well. So as Suzanne's explained, I'm the President of the ACT Human Rights Commission. It's a role which I'm deeply honoured and privileged to hold, and I've been in the role for the last 6 months, having come back from Aotearoa, New Zealand. And I'm going to be presenting with Karen Flick, who will talk more about cultural rights and the United Nations Declaration on the Rights of Indigenous Peoples. I'm going to do a bit more of the explaining about our Human Rights Act in general terms. My role is both President and Human Rights Commissioner, so I could talk about the Human Rights Act for years, but I promise I won't do that. As President, I have this kind of unusual role of bringing together 4 independent statutory officers. So there's me as the Human Rights Commissioner, and then we have 3 other commissioners, one of whom, Karen Tui, deals with disability community services, health services and so on. She has all of the complaints jurisdictions. The other, Jodie Griffiths-Cook, is the Public Advocate and the Children and Young People's Commissioner, and then we have Heidi Yates, who's the Victims of Crime Commissioner. And so my role is kind of to be a linchpin and to ensure that we work together on things where we need to work together and do some more mundane things around human resources and finances as well. So today, what are we going to look at? We'll talk about the ACT Human Rights Act. I am a lawyer by training. I'm assuming most of the people in the room don't have legal training, so we're going to try not to scare the hell out of you. We are very interested though in why you're doing this course, and we'll ask you some questions about that. So we're going to talk about the Act. We're going to talk about the fact that the cultural rights of Aboriginal people and Torres Strait Islanders are protected in our Human Rights Act at Section 27. And we're going to talk about this very important international document, the United Nations Declaration on the Rights of Indigenous Peoples, or UNDRIP as it's called for short. We'll have a few little activities where we'll get you to pair and share on some questions that we want to ask you, and time for question and answer, I hope. So we do want to keep it fairly informal and, you know, and interrupt if you need to ask a question. Okay, now, it's a while since I've been in the classroom, so I've forgotten how to drive a PowerPoint.
If you just hit...
that way, yep,
yeah.
Excellent, all right, easy. So about the Commission, what do we do? So we administer various pieces of legislation, including the Human Rights Act, and we handle complaints in the area of health services, one of the areas which is very important to you. We raise awareness of rights and responsibilities. We provide a lot of advice to government. Quite unusually, we are one of the few human rights commissions, I think, in the world, and certainly the only one in Australia, that gets access to cabinet submissions. So while legislation is being drafted by government, we're able to have a look at it and try and prevent bad things from happening. We do advocacy for children, young people and vulnerable adults, particularly through the Public Advocate and the People and Young Children and Young People's Commissioner. And we provide support for victims of crime through the Victims of Crime Commissioner. Whoops, keep doing the wrong thing there. Okay, so how might this be relevant to you? We might just ask a question here. Why are you doing this course, and what do you hope to do with it? We're really interested. It's a fantastic course that you're being offered here. What is your interest in this area? Why are you doing it? What do you hope to do with it at the end of the day? Don't be shy. There's no stupid answers. Yep.
Well, as with, I'm sure many people here, it is a compulsory course for the degree.
Okay, interesting.
But
So you have to. Yeah.
aside from that, I I was excited to basically, in addition to learning about Aboriginal and Torres Strait Islander health, like get some more cultural competency training sort of in general. I currently work in a GP practice with a non-English speaking doctor, and we have a lot of foreign patients, or patients who don't speak English very well. And so I see it like every single day, like so many patients who require that sort of cultural competency and cultural understanding in the health sector. And Australia is super multicultural, so you just see it all the time. So I was hoping to learn not only about Aboriginal and Torres Strait Islander health issues and cultural competency for Aboriginal people, but also for just in general as well.
Yep, great answer. Yes, go ahead.
Sorry. I don't do the medical science course, so it's not compulsory for me. But I'm ideally wanting to do, like, go into clinical psychology. And cultural competency is something that I think is very much lacking in our health services. And even though it's probably one of the most integral parts of the services, just because it also makes your life easier, let alone is beneficial to patients. And I just have a general interest in Indigenous Australians and the history, learning more about the true history, which we've done quite a bit of, and also how we can better navigate the future in terms of making sure everyone receives help that they deserve.
Fantastic. Okay, so some great answers there, and that's really helpful to us. It gives us a sense of where you're coming from. So we will be focusing basically on some legal obligations that are relevant to you if you end up in the public health system. There are ways in which the Human Rights Commission is relevant to all people, health practitioners, even if you're in private practice. As I mentioned, the Health Services Commissioner can hear complaints about delivery of health services, and that will apply to people in private practice as well. But the Human Rights Act is really about obligations on governments and what we call public authorities who are delivering services for the general community. And public health services are most certainly caught by the Human Rights Act. So I've just given you some key sections there, Section 40B of the Act, and hopefully you've picked up a copy of the Act, says that public authorities must act consistently with human rights and properly consider relevant human rights when they're making decisions. And it makes clear that delivery of public health services means that you are part of a public authority who's caught by that obligation. As we'll see, human rights are about actions or decisions being necessary and proportionate. There's sometimes a balancing of different rights in play. And we'll talk in particular about cultural rights of Aboriginal people and Torres Strait Islanders. So first of all, what are human rights? And again, can I ask for a general sense of what you think human rights are? Anyone able to give me a definition? Go ahead.
They're something that every single individual in the world should have, that they're integral to living really a good life, that theoretically everyone should have, but maybe not everyone actually does.
In practice, exactly. And so our human rights in the ACT sets out to protect at least some of these important human rights. So the idea of rights has quite a long history. You can talk about liberal philosophy, but in international law, of course, it's after the Second World War and the Holocaust that we see international instruments being developed, like the United Nations Declaration of Human Rights. And it's the idea that they're the things that are necessary to protect the dignity of all human beings. And we say that human rights are inherent to all of us. We have them simply because we are human beings. They're universal, so everybody has them. It doesn't matter what you look like or what you do even. People who commit crimes, for example, still have human rights. and they are indivisible, interrelated and interdependent. So you can't separate out rights. They all support each other. We need all of them to live a truly human life. And then we talk about governments having corresponding duties. So first of all, governments must respect rights. That means that they mustn't interfere with rights themselves. Then they must protect them. So they should be taking steps to ensure that private individuals, enterprises, corporations and so on are also acting in accordance with human rights. And then governments should take steps to fulfil human rights. And that might involve the expenditure of resources. And traditionally we tend to talk about at least two categories, or sometimes we call them generations of rights. The first being civil and political rights, the second being economic, social and cultural rights. And generally civil and political rights are often thought not to have financial implications. So we're talking here about things like freedom of expression. I can get up on a street corner and spruik my views. I don't need money to do that. But even those sorts of rights often do require resources. So if you think about the rights of an accused in the criminal process, that requires a court system, it requires legal aid to ensure that people have lawyers to represent them. It actually involves a huge expenditure of resources. The other set of rights, economic, social and cultural rights, are things like the right to work, for example, or social security. And obviously that's going to require government to expend some resources to provide it. The right to health would be another of these rights, and that's going to require governments to provide resources to fulfil those rights. Okay, so this is a bit of a list of what we've got. Hopefully you can all see it at the back and the colour scheme's okay, of the rights that are set out in our Human Rights Act. And I should say, with some pride, that the ACT was the first jurisdiction in Australia to adopt a Human Rights Act. We now have one in Victoria as well and one in Queensland. We still have no national charter of human rights. Our Act turns 20 this year, so yay for the ACT. Okay, so I just want to get you to do a little bit of an exercise. Have a look at those rights and talk to your next door neighbour about what's in there. What do you think is missing? Are there some rights there that you think should be there? And what sort of implications do these sorts of rights have for you as students of health? Okay, so just give you a few minutes to talk to your next door neighbour about what's in there, what implications does it have for you, and what's missing. Okay? Just a couple of minutes, talk to your next door neighbour about that. Okay, is that enough time? Just a quick little exercise there. I've got people talking, that's great. So now, report back. Which of the rights do you think would be most relevant to you as aspiring health and allied practitioners? What do you think would come up most often? Yep.
Well, I'm looking to be like a child psychologist, so the protection of children is important.
Okay. Yep. Okay. So protection of children's rights in particular. Okay. And we might talk a little bit about that later too. What does that actually mean? Yes.
There's the right to hold opinions. So if you're giving your medical advice to a patient and they don't want to do that, or they have a different opinion, you kind of have to respect their opinion, give them the information, but you might not always be able to convince people what you think.
Yeah, well, that's an interesting into that, and certainly informed consent. You can't just impose a medical treatment on a patient, right? And that's very clear in human rights law. So that's certainly something that you have to be aware of. What else might come up? Yep.
The first one, equality and non-discrimination. It would be important in the medical field. You can't not provide treatment or if someone is the race that you don't like or something like that.
Yep.
Or you can't, I don't know, experiment on people who are of a different race or anything like that.
Absolutely. And I guess when we think about cultural rights, we're trying to think about how do we make sure that we give the right advice in a way that's appropriate to a person from a particular culture. I've got quite a few hands up. Yes, up the back there.
No limits on adopting the religion of all.
Yes.
You know, as a, like, if I'm going to be a medical practitioner or something, that's something I need to keep into consideration, that sometimes some medical procedures don't conform with someone's religion or culture and stuff, and I need to be culturally aware and sensitive when talking about patient.
Yep. Fantastic. I'll take maybe 3 more hands. You're doing really well. Yep.
I actually had like a question.
Sure. Yep.
I was just thinking, like, as I was reading through these, like the field of like assembly work and cultural rights of Aboriginal and Torres Strait Islander peoples, and I was sort of like thinking about where's the balance between like in a public health emergency, like these rights are taken away by the government, and
Yeah.
I guess in what situations is it okay to overrule these human rights for something like health?
Fantastic. So we're going to get into that. We haven't given you on a slide a very important provision, which is section 28, which talks about when you can limit rights. And I do want to ask you a question about the pandemic. So fantastic, you're ahead of me there. I think, yes, one here and one here. Yep.
The right to life, I think, is
Yes. Yep.
super important
Yep.
in medical practice.
Absolutely. Yes.
I was just going to say, I think it's interesting looking at all these rights. There's really specific ones on like compensation if wrongfully convicted and specific to like the criminal justice system, which is something I have. It's not something that I think about every day because I'm from like a health sort of background. So I think it's just interesting, like the background work that goes into this is obviously done by lawyers and are very like focused on that. But health is not mentioned anywhere in this. But I guess as medical practitioners or future medical practitioners, we haven't had maybe a lot of say in like this legislation on human rights, and so we're sort of like drawing these connections, but it doesn't say health or
No,
anything on
it
there.
doesn't talk about the right to health. So that was my other question, what's missing, right? Did you want to say something? Yep.
More of a question, kind of.
Yep.
Because we talked about the right of life before, but what if someone doesn't want that right to life?
Ah.
They want to end,
Voluntary assisted dying, yes. That was
override their right to liberty, or
well, it's your inalienable right to life, so no one else can take it away from you. But if you don't want to go on living, that should be your choice. And there's plenty of human rights jurisprudence now going in that direction. And now the ACT has joined nearly all the other states and territories. I think the Northern Territory is the one jurisdiction that does not have legislation for voluntary assisted dying. The tricky issues around that being, of course, you can take your own life, but what if you actually need help to end your life? And so there are some quite fraught questions around that. Human rights is lovely. They're lovely instruments to read, unlike pieces of legislation, because they're set out in very broad terms, but then there's lots of room for interpretation. Okay, so health is missing. Anything else that sort of jumped out at you as missing? Yep.
Self-determination, and I think for many to make decisions about one's own communities is really important to exercising all of these human rights.
Yeah.
Because without representation and governance,
Yeah.
how can you make sure that that's actually going to
Yeah.
communities?
Yeah, so there are some broad things around taking part in public life that get towards that issue of representation, and that would probably cover most people, but when it comes to, say, First Nations people, do you need more than that? And in the ACT we've tackled that through cultural rights, so we now not only recognise general rights of minorities to practice their culture, religion, language, but we now talk about the cultural rights of First Nations people in this country. Self-determination is not there. And that's another category or generation of rights. It's like a group or solidarity right. Well, now, when we think about why isn't it here, I don't think it's just the lawyers. I think it may be the legislature and their worry about expending resources. So remember, the right to health, it is protected by international human rights law. Okay, so it's in the Universal Declaration of Human Rights, this very important instrument adopted by the General Assembly of the United Nations back in 1948 after World War II. It is also in a very important treaty, which is a binding agreement between nation states, the International Covenant on Economic, Social and Cultural Rights. But we haven't implemented most of that covenant in our Human Rights Act. So we've got the right to work that was implemented at a later stage. We've got the right to education. We've always had some aspect of cultural rights because oddly it's the International Covenant on Civil and Political Rights that has the general right to protection of minorities' culture. And we've expanded on it to recognise some rights in this other very important instrument, the United Nations Declaration on the Rights of Indigenous Peoples. So why haven't they done it? I think mainly, and you see it in Queensland and Victoria as well, very limited economic, social and cultural rights in those pieces of legislation. And I think it's because of the fear of resources. And do we want the courts involved in overseeing what governments might view as rather political decisions about where to expend resources? So I think that explains why there are a hell of a lot of things that we might want to see in our Act and they're not there. And one of my foci as President will certainly be to try and make sure that we expand our Act to include these other important rights. It's all very well to talk about the right to freedom of expression, but if you're too ill to exercise that right, it's kind of meaningless. Remember, the rights are indivisible, interdependent, interrelated. Okay, so great responses to that. All right, at this point, because I'm aware that we're probably already at the halfway mark, time is going very, very quickly. I might hand over to Karen to talk about cultural rights. Perhaps just before that, I did mention this very important provision, Section 28. So we might just talk about that and the COVID pandemic. So when you look at 28, it says that human rights may be limited. It's very rare that a right is just absolute and cannot be tampered with. There are some. The prohibition against torture. You cannot torture people at any point in time. It doesn't matter what they've done. Doesn't matter if you think they're terrorists and you've put them in Guantanamo Bay, for example. You cannot torture people. But most other rights you can limit. And Section 28 talks about the conditions on which you can limit human rights. So it says, first of all, they may be subject only to reasonable limits set by laws that can be demonstrably justified in a free and democratic society. And in deciding whether a limit is reasonable, you must consider the following factors. This is an inclusive, not an exhaustive list. The nature of the right affected. So if it's torture, sorry, we're not getting into limitations analysis. The importance of the purpose of the limitation. The nature and extent of the limitation, the relationship between the limitation and its purpose, and are there any less restrictive means by which to achieve your goal? So the question asked earlier, during the COVID pandemic, if we went back to that list of rights, which I might be able to do if I just press on that, hooray, how many of these rights were effectively limited, sometimes even kind of denied completely during the pandemic? Yep.
Freedom of movement.
Yes, absolutely. Liberty, you know, yep.
Kind of right to work, or even in some cases right to education.
Yes, it did impact on the right to work and right to education. Yes.
Also, in some ways, like the cultural rights of Aboriginal and Torres Strait Islander peoples, because like restricted movements.
Yes, and now maybe sometimes communities were asking for those limitations. I was in Aotearoa, New Zealand at the time, and sometimes it was Maori actually pushing for the restrictions where, on the basis that very vulnerable community, please don't bring this disease to us, yeah? So that's a situation where we did impose limits, and we're looking at various inquiries to think about, are there some circumstances in which it all went too far? When you think about that list in section 28, and you can look at that later, you've got your little pocket copy of the Act. Obviously, it was a very important purpose we were trying to protect. We were trying to protect not only the right to health, but actually life itself. Absolutely fundamental. So there's no doubt about the goal, right? But did we sometimes go too far in the restrictions imposed? Were they actually not proportionate limitations? So one of the examples given in Victoria is when they closed down those public housing towers and people couldn't even get their prescriptions, and it was just chaos and they couldn't get food and so on. So there were some examples when we went too far, although with a very important goal in mind. So I hope that kind of gets to that very good question that was asked earlier. I'm now going to hand over to Karen Flick, who's going to talk more about cultural rights and then the UN Declaration on the Rights of Indigenous Peoples. And I might ask you that.
Which button do I press here?
So you're on
yes.
cultural rights there and you just press that.
Okay. Thank you, Penny. I'd like to acknowledge that we are meeting on the unceded lands of the Ngunnawal and Ngambri peoples. I pay my respects to their elders past, present. I also acknowledge other Aboriginal and Torres Strait Islander people in the room today. I pay my respects to your elders and your traditional lands. I'd like to acknowledge my ancestors. I'm a Bigambul Gomeroi Yuwalaroi woman, Northwest New South Wales, Southwest Queensland. I work at the ACT Human Rights Commission as the Aboriginal and Torres Strait Islander Cultural Advisor and Community Liaison Officer. So my role there is basically to engage with community, to inform them about the services, the rights, and to access the various parts of the Commission. My role also is to inform Commission staff about Aboriginal and Torres Strait Islander issues, to inform them about history, context, engagement, and also to provide advice from time to time on legislation as it comes through, or any other consultations that government comes across. So I want to talk to you a little bit about cultural rights, section 27.2, which is in the Human Rights Act that you've all got. That specifically focuses on the distinct rights of Aboriginal and Torres Strait Islander peoples in relation to their ancestors' lands, cultural heritage, traditional languages and knowledge and natural resources. It's based on Article 27 of the International Covenant on Civil and Political Rights and Articles 25 and 31 of UNDRIP, the United Nations Declaration, which we'll cover off in a little while. It covers the ACT jurisdiction, which includes Jervis Bay. Covers all Aboriginal and Torres Strait Islander peoples in the ACT, and It's also been addressed through different actions taken in courts. Not a lot in the ACT, but we do have one example. Penny might just get you to just talk quickly about the Williams case.
Yeah, so there have been a couple of cases or situations involving cultural rights where the Commission's been involved. One recent one to look out for, because we still haven't got the decision from the Supreme Court. It involved an Indigenous woman in the jail here who was not allowed to have leave to go for sorry business, to attend a funeral. And so in that case, the Commission has powers to intervene in litigation. It doesn't actually act for people, as you know, take on clients, but we have the right to intervene in litigation and put arguments concerning human rights. And we made arguments about a number of human rights, but one of them in this instance was the cultural rights of the person concerned. So she was the oldest child of her father, I think, was being buried, and she should have been there to read the eulogy. So that's an example of cultural rights in action, not in a health context, but in a criminal justice context.
Thanks, Penny. It's also in a health context in terms of how people engage with community during sorry business, what their obligations and responsibilities are. That's about their well-being. That's about also well-being of the family, of the community, and acknowledging the person who has passed away. So it's all health, well-being, spiritual connection, obligation, responsibility. But those, as we said, we're waiting the outcome of that. We talked a little bit earlier about public authorities' responsibilities. There's still a long way to go in the ACT in relation to challenging cultural rights in the context of whether it's housing, health, employment, education, and some of those issues are coming forward to the Human Rights Commission, but still a long way to go in terms of getting the actual structures or the agencies, the public authority agencies, or those that deliver the functions of public authorities, still a long way to shift and incorporate cultural rights into that. I think we've pretty much covered this, but I just want to pick up on the point about it's about our right, must not be denied, to maintain, control, protect and develop cultural heritage, distinctive spiritual practices, language and knowledges, kinship ties, all of that uniqueness about being an Aboriginal or Torres Strait Islander person. It's a distinct right, unique to being Indigenous to this country. That's why it's different to other rights, I guess. There are aspects, examples of, including equal participation in cultural activities like funerals we've mentioned, NAIDOC Week activities, other cultural activities. Also, with those that are in AMC, having access to in the jail, the Alexander McConaughey Centre, having aspects of their continuation of culture as well, whether it's through music, dance, art, horticulture, and also accessing country in terms of protection of land and land management, following that through. Just wanted to also mention that with section 27.2, it is based on the United Nations Declaration on the Rights of Indigenous Peoples, and I'll come to that in a little while as well. So these are basically some of the cultural rights that we've already covered, but this slide just shows the interconnectedness with kinship ties, beliefs and teachings, observances, spiritual practices, and once again, it's not just the rights that are included in the Act, it's also on an Aboriginal or Torres Strait Islander person, our responsibility and obligation to be able to fulfil that and not be denied. I might just hand over to Penny again to just cover off a couple of parts of the UNDRIP in the international context. So this is why it's a bit of a tag team thing.
So just in terms of what is UNDRIP, so it's a General Assembly resolution adopted by the United Nations. It's not a binding instrument like a treaty. So when you have a treaty, like the International Covenant on Civil and Political Rights or the International Covenant on Economic, Social and Cultural Rights, countries are generally there at a conference, they sign on to the treaty at the time, and then afterwards, sometimes after consulting with national parliaments, they will send in what's known as an instrument of ratification and say, yep, we're definitely bound by this now, we've ratified the treaty. So there's no such process with a General Assembly resolution. It's done by a vote or sometimes by consensus. And formally speaking, countries haven't said, yeah, we agree to actually be legally bound and carry out these obligations. So sometimes when you're speaking to people, particularly of course First Nations themselves, there's some disappointment about that. Well, why have countries only adopted this non-binding instrument? Does it really have any meaning? As an international lawyer, I think it really does, because it often builds on those binding treaties. So someone mentioned the right to self-determination before. This is a people's right, and it appears in Article 1 of both the Civil and Political Covenant and Economic, Social and Cultural Covenant. UNDRIP spells out that Indigenous peoples also have the right to self-determination. So it's building on binding law and it's interpreting it. So I think it's pretty important, saying that Indigenous peoples also have the right effectively to determine their own destiny. Now, why was it a non-binding instrument? I reckon you can probably imagine why. You may have even followed some of the controversy, many years ago now, at least a decade ago. It was the colonial settler countries, the United States, Australia, New Zealand, Canada, with large Indigenous populations who were terrified, apparently, about the prospect of secession or separation. That was their fear, and I guess that's why it'd be hard to get a binding treaty, but we have at least got this very important non-binding instrument that can be used to interpret the binding treaties. It is also a declaration, and when the UN says this is a declaration, in a sense they're trying to say we're declaring what is. So the Universal Declaration of Human Rights, very important instrument, it's now recognised as having binding force. It's part of the unwritten customary international law, and I guess when the UN says we've got a declaration on the rights of Indigenous peoples, they're trying to spell out this already exists. This is not about states signing on, ratifying and saying we agree to be bound. Okay, that's probably enough from me. Back onto the main game.
Thank you.
Yep.
So just want to take you through, this is the UN Declaration on the Rights of Indigenous Peoples. There is a link at the end of the slides that we've left for you to have a look at, and some of you may have already covered some of the articles previously and some of the work that you've done. But there are foundational rights, self-determination is a central right, the right to have institutions and to have self-government. I won't get into it, but the recent discussion or the referendum in regards to having a voice, those sorts of things are addressed in part of this and part of ongoing conversations in the Aboriginal and Torres Strait Islander community as well. Life and security, there are articles that cover that, right to life, security and liberty, etc. Right to be free from genocide, forced assimilation and the destruction of our culture. Another area is language, cultural and spiritual identity, and those are some of the articles that we've incorporated into section 27.2. Education, information and employment, the right to access the same standards of education as all other Australians. There have been many cases where children have been denied access to education in Aboriginal and Torres Strait Islander communities. Previously it was pretty much segregation, and now sometimes It's through suspensions, it's through all other measures, so still there's a denial of rights in regard to that. Some of these cases have been challenged, or a response in some areas have been where Aboriginal and Torres Strait Islander communities have set up their own education systems. Right to country resources and our knowledge, and free, prior and informed consent. So some of those articles that cover those areas are actually being challenged in courts around the country as we speak. That's all I want to say about the United Nations Declaration on the Rights of Indigenous Peoples, but also to let you know that last year, or 2022 and 2023, the Australian Parliament's Joint Standing Committee on Aboriginal and Torres Strait Islander Affairs conducted an inquiry into the application of UNDRIP in Australia. So it was a fairly comprehensive inquiry. They've released a report that we can also provide the link to the school if people are interested in that. They have made 6 recommendations. Recommends that the Commonwealth Government ensure its approach to developing legislation and policy on matters relating to Aboriginal and Torres Strait Islander peoples, including but not limited to closing the gap, be consistent with the articles outlined in the Declaration. The committee recommends development of a national action plan in consultation with Aboriginal and Torres Strait Islander peoples. Committee recommends that any national action plan should consider the legislative, policy and other approaches to implement and assess compliance with the Declaration. And there are a couple of other recommendations as well. I won't go into it, but suffice to say there has been a parliamentary inquiry, a report is out, government is now considering it, and it is focusing on application of UNDRIP in Australia. So whilst it's a declaration, it's non-binding, it may end up being, some aspects of that may be binding in terms of how government responds. Not sure of the time frame of when that will be, addressed. Also just want to talk about using the Declaration and how have Aboriginal and Torres Strait Islander peoples used international law. Not necessarily the Declaration, but have gone to or presented to the United Nations Human Rights Committee. So one of them is in relation to climate change. So a couple of years ago, reasonably recent, 8 Torres Strait Islanders and 6 of their children from Boigu, Poruma, Warrabir and Masig, 4 small low-lying islands in the country's Torres Strait region, complained to the United Nations Human Rights Committee that Australia had violated Article 2, which defines the scope of legal obligations, Article 6, the right to life, Article 17, the right to be free from arbitrary interference, Article 47, the rights of children to protection, and Article 27, the right to enjoy culture together, the identified human right. They claim that changes in weather patterns have direct harmful consequences on their livelihood, their culture and traditional way of life. They indicated that severe flooding caused by the tidal surge in recent years has destroyed family graves and left human remains scattered across their islands. They argued that maintaining ancestral graveyards and visiting and communicating with deceased relatives are at the heart of their culture. In addition, the most important ceremonies, such as coming of age and initiation ceremonies, are culturally meaningful if performed in the community's native lands. They also argued that changes in climate with heavy rainfall and storms have degraded land, trees and waterways and reduced the amount of food available from traditional fishing and farming. So that was one case where Torres Strait Islanders have actually presented to the United Nations. There's ongoing action around that and varied responses from the Australian government in terms of dealing with that. And it not only affects the Torres Strait Islands, it affects all around the low-lying coastal areas and communities that are there. I just want to talk about another one quickly, children in justice. So Duane Hussein, who was aged 12 at the time, was the youngest person to present to the UNHRC. If you've seen the film In My Blood It Runs, and I'll recommend you have a look at it if you haven't, it covers his story at the time. And he presented to the 42nd session of the United Nations Human Rights Council, and he raised issues including raising the age of criminal responsibility and Indigenous-led education. I'll just do a quote from Duane. He said, "I am the star in a new documentary, In My Blood It Runs. The film shows why I felt like a failure at school. I was always worried about being taken away from family. I was nearly locked up in jail. I was lucky because my family know who I am. They know how smart I am. They love me. They found a way to keep me safe. There are some things I want to see changed. I want my school to be run by Aboriginal people. I want adults to stop cruelling 10-year-old kids in jail. I want my future to be out on land with strong culture and language. My film is for all Aboriginal kids. It's about our dreams, our hopes and our rights. I hope you can make things better for us." Duane comes from a very strong family. His grandparents and great-grandparents have stood us, strong leaders in the community around Alice Springs, Mbantua, and if you are familiar with Children's Ground, his family is also part of that. So that's about Indigenous-led education. They haven't received any government funding to date, but they're building young people, growing strong, babies right through to, before they enter the mainstream system. So they are strong and confident in their culture, in their language, in their practices. But I recommend seeing In My Blood It Runs. The last one, and I think Suzanne mentioned that you've already covered Aboriginal deaths in custody in your course in some area. Latona Dungay, mother of David Dungay Jr., submitted a complaint to the United Nations Human Rights Committee arguing that the New South Wales government failed to protect her son's right to life and that successive Australian governments had failed to implement all the recommendations from the 1991 Royal Commission into Aboriginal deaths in custody. Latona said, "Governments are not listening. No one is accountable and responsible or is going to be prosecuted. So the only avenue we have is to raise it at the United Nations." She said, "My son had a right to live. He had the right to be safe from harm. And I have the right to demand accountability and justice for what happened to David. The government and the prison had a duty of care to keep him safe, with people who had properly trained to keep him alive. The system failed and David lost his life because of that failure." As of January this year, the Australian government has said that it will not challenge Latona's complaint. Doesn't mean that anything has really been addressed, but it's about raising the profile, raising the issues in that international setting and exposing Australian government's responses. So I just wanted to share those sorts of activities with you, or that information with you. I think we've already sort of talked about, well, what are the implications for people working in government allied health medicines, and we've already covered the requirements under public authorities. But in your areas, what do you think are the implications for Section 27.2 for people working in the public health system?
Actually knowing about it, first off, and having, because I think what you spoke about, how it's kind of very broad recommendations and kind of, they're not rules, but they're implied things that you should be doing. Having an understanding of actually what you're speaking about, not just knowing what it's saying.
Anyone else? So this is when you're working out there and you are in either working in a in the public health system, so you're a public authority, or you are delivering in a private health practice, delivering a public health function. So you're still required to adhere to the requirements of the Act, and Section 27(2) is incorporated under the Act. Yep.
Would it be involved with the APRA regulations surrounding cultural competency, cultural safety, and the ability to take complaints to the health board surrounding failures of doctors and other medical practitioners to adhere to those standards?
Yes, definitely. I mean, APRA has already established their strategy, their protocols. They cover a lot in cultural safety requirements and principles. So definitely that fits within that. Yep.
I'm working in the National Redress team at the moment, and I'm working in the incarcerated team, so a lot of everyone's incarcerated, and a lot of the applicants are Aboriginal and Torres Strait Islander, and something that is important that we do is acknowledge how they would like to go about their application, as far as part of the application is they get an apology at the end, and we offer smoking ceremonies, and they can let them let it be led by them how they should have apology.
Yeah. Okay, thanks for that. More thinking to be done, and obviously when you're in your workplace, keep those things in mind. There are, Penny mentioned, cultural rights in other jurisdictions. The Queensland Human Rights Act, they have their Section 20 on cultural rights, and I've included the link there. And Victorian cultural rights as well, under their charter, Victorian Charter of Human Rights and Responsibilities. So this is our cultural safety charter at the Human Rights Commission, Ngatai Yiding, which means listen good, or good listening. We have our values outlined there, and we focused on 4 priorities. The journey, I guess, for the Human Rights Commission was that it also had at the time, a couple of years ago, a reconciliation action plan. It decided it wanted to, well, the commissioners actually decided that they wanted to take it in another direction and not just be focused on some, activities and that you tick off maybe once a year, or the reporting is too comprehensive, but it's about shifting to be a way of how we embed principles into the ongoing work. So people's rights, we acknowledge and incorporate Section 27(2) into that, and we also include cultural and religious rights under the Discrimination Act. We accept that Aboriginal and Torres Strait Islander peoples have the freedom to live well and to live according to their values and beliefs. Aboriginal and Torres Strait Islander staff are supported to fulfil their cultural obligations. Probably one of the key things that goes to the core of cultural safety is that all staff across the Commission are supported to undertake a process of reflection on their own cultural identity and any unconscious bias. And that's ongoing. It doesn't, you don't just go through I guess the other thing about cultural safety is you start with cultural awareness. That's that basic understanding of difference, of uniqueness, of operation of cultural, being aware of cultural requirements. Then there's cultural competency, and some of those things I guess you're going through in your own courses, but will also go through in your workplaces as well. That's an ongoing journey. And cultural safety is the big shift. It's about safe services. So with cultural safety, our definition is that safe service is defined by the people who receive the service, and is based on the experience of those accessing the service. So that's where the big shift comes. I won't go through welcoming place and engage with trust and respect, because that's probably reasonably straightforward, but it's about being conscious of those sorts of things within the Commission in an ongoing context. But providing safe services under a cultural safety banner is really about addressing the individual person's perception of their own biases, where they come from. So if you've got a patient in front of you or somebody presenting with an issue, you may think that you're delivering safe services and you're doing your little checklist in your mind, but the checklist that really matters is how they have felt in terms of they are in control of defining whether they've received a safe service. So I'll leave that last comment with you, and I've just put some references there. I'm not sure whether a lot of these organisations, the Indigenous Doctors, Congress of Nurses and Midwives, NACCHO, Torres Strait Islander Health Workers and Practitioners, and of course APRI you've mentioned, most of those organisations have their head office in Canberra. A lot of those, you've checked out the websites, but a lot of them, well all of them I'm pretty sure have the cultural safety training, principles, guidelines, frameworks, but also if you're going to work in other jurisdictions, Queensland have Aboriginal and Torres Strait Islander health frameworks, Victoria, pretty much all around the country. There are frameworks within the public health and within the national. I'll leave it at that, and we've got some questions.
Is there any conflict between the different rights or regulations of New South Wales and ACT? Obviously, Indigenous land doesn't extend in those borders.
Do you mean in provision of legislation?
Yes, like that. Just like, is there conflict? Like, say that there's someone from a Ngunnawal person in New South Wales, but their land is also in the ACT. Is there ever any difference between those regulations and policies which can affect that person if the land extends over that border? That's the ACT.
Oh, look.
Well, I guess, the lawyer's answer would be yay to the ACT because we've got a Human Rights Act that actually recognises some rights. New South Wales is not one of the jurisdictions that has a Human Rights Act. Things to do with native title and land rights are really covered at the federal level by the native title legislation. But yeah, for sure there can be conflicts between how someone might be treated in a human rights jurisdiction versus a jurisdiction that doesn't recognise human rights. And we have people who live in Queanbeyan and come and work in the ACT, so it is kind of a live issue. That's a good question.
And people take action through courts as well to challenge that.
Sorry, it's a bit of a dumb question, but how is it possible that some states don't have that legislation like New South Wales? Like, how is that? I don't understand.
Look, there's a whole, Karen might have different answers to me. I come at it as an international lawyer, and I've been very influenced by particularly the writings of a mentor of mine, Hilary Charlesworth, who's the Australian national sitting on the International Court of Justice and, busily looking at genocide and Gaza and so on. And she has said, I think Australians have traditionally been reluctant about the rights idea. We've relied on democracy to protect us. We don't have the history of the United States, with the war of independence and so on, and the sense of limited government and wanting to protect the rights of individuals. And now we might be having some second thoughts about whether democracy always protects all of us. If you think about the COVID example, that was a challenge to the rights of everybody. And of course, for First Nations people, democracy is not enough. We're talking about 2 to 3% of the population. So in the ACT, we had a particular government who thought it was a good idea, led by John Stanhope, and they decided to be the first jurisdiction, and then Victoria and Queensland have followed. There's now yet another push to have a national charter of human rights, but who knows when and if that will succeed. So it's interesting, isn't it? Because I reckon most Australians think our rights are well protected, but in fact most of the time we don't have these sorts of protections that we've got in our Act and the ACT in place. We're not legally well protected. So many
Just
questions.
stop the back.
Yes.
Just on your point about by government, basically, not a charter of human rights. Australia was built on a lie to start with. So and in our constitution, women weren't named. So Aboriginal people were excluded from that right in the beginning. Women were excluded from when we became a federation. Aboriginal people weren't then included until 67. So that premise is fundamentally flawed at its core. And I don't think Australia realises just how flawed that premise is. And when things are challenged and they realise just how flawed it is, such as COVID and our movement, that's when things start to change to a rights-based as opposed to a governmental protection-based.
Yeah, it's when rights are under threat, that's when people will rally and say we ought to have some more legal protections, and is our constitution any good, and should we change it, and so on. Yeah, agree with you. So many more questions here.
Right at the back, and then we'll go there and there and there.
Yep.
Just going back to the UN documents, like the Declaration on the Rights of Indigenous People, and just like the General Declaration of Human Rights. I think a lot of the countries that have signed, I mean, we continue to see, like, say China and Burkina Faso continue to violate those human rights that they agreed to abide by, and I think a lot of people realise that there's this disjoint sort of nature between them violating it and the lack of accountability that comes from that. So, like, from your sort of perspective, from a more international basis, how should we get people who have signed these documents to actually conform to those standards, and when they don't conform, how do we get them to take some accountability and have some sort of overarching international,
Yeah, it's really hard. I mean, this is the international law's dilemma, that it's not well enforced. What I'm finding interesting at the moment is that even when there are these massive violations, I mean, we can talk about genocide, but we can certainly acknowledge violations of international humanitarian law going on right now in Gaza. It's interesting that so much time is being spent bringing particular cases to the International Court of Justice. There's a sense, I guess, that it's at least symbolically important, and that it also plays a role in pressuring states, even if they might choose not to abide by the decision at the end of the day. And I guess we've always relied on that in human rights. It's kind of the naming and shaming of particular human rights violators. But it's true, it's not as simple as in the ACT, where you can go to the Supreme Court, and in fact from June you can actually come to the Human Rights Commission and have a conciliation of a human rights complaint, which means there's much more access to justice than going to the Supreme Court. It's a big dilemma. Yeah.
So we'll just go here.
I was going to say,
Yes,
let's limit it to two.
Yes,
okay,
we're probably
All right,
cutting
those
into
two.
the rest of your class. Yeah.
I just want to go back to Joey's point of like why we don't have it across all states and territories, and you said because we have our faith in our democracy. Is that why? Because we don't want to take advice from non-elected international organisations, because we have faith in our own democracy. Is that
I think there's a little bit of a nativist push there for sure. So, I mean, you're all most of you are much younger than me, but you might remember during the Howard government, there was a real pushback against the United Nations bodies like the Human Rights Committee that supervises the Civil and Political Covenant, and it was very much based around these faceless people of the UN and who are they to tell us what to do, which of course ignores the fact that Australia was there at the founding of the United Nations, Doc Evatt was there, we were very involved in the establishment of the UN human rights system, so it's a bit ridiculous to turn around now and say we don't like this stuff. But yeah, there's often that kind of populist, we don't want them telling us what to do, as opposed to thinking about we've actually voluntarily signed on to these treaties, we were there when they were drafted, we were instrumental in them being adopted. Hillary, again, just as my mentor, she says Australia has something of a split personality. We say these things at the international level, but when it comes to implementation, we're not that great.
so? I guess my question was then: do we think the change will happen when there's this consensus that we don't have our faith in our democracy anymore? Or
Well, I don't know. I mean, you're opening such large political and philosophical questions. It worries me that young people are not as enamoured of democracy these days any longer. I'm a fan of Winston Churchill's saying that democracy is the worst form of government, accepting all the others that have been tried from time to time. It's a pretty good start, but it doesn't do much to protect minorities, and it's not great at protecting First Nations people in particular. Yeah.
Just the last question.
I was just wondering, in terms of the cultural rights for children in out-of-home care and like young people in juvenile detention, are there any like strategies in place to protect kinship and connection to country in terms of rights?
Look, a couple of things, I guess. The ACT has recently appointed an Aboriginal and Torres Strait Islander Children's and Young Persons Commissioner in its own right, Vanessa Turnbull-Roberts. So she's probably, February, she started in February. So there's now that specific commissioner role. I think a lot of the things are going to start to come through her responses, her challenges. The Our Bourai's Our Way, which was a report that was done a couple of years ago, made that recommendation to have a separate Aboriginal and Torres Strait Islander Children's and Young Persons Commissioner. And I think the statistics about the number of Aboriginal and Torres Strait Islander kids in out-of-home care continues to rise and rise and rise all across the country. In the ACT in particular, it's very high per head of population. And there absolutely needs to be something done about changing the structures, changing the systems, changing the process. And, there's been a lot of talk about that for a long time. But I think, I'm hopeful that we've now got a commissioner. I'm hopeful that issues that can be raised will be raised. It's difficult because of the privacy in relation to we can't name a child, we can't do anything about a child, we can't access records about a child. So all of that sort of stuff is protected in one sense, but absolutely necessary to address all of those issues. Hopefully Section 27.2 comes into play a lot more in relation to that.